Hello everyone, welcome back to our Learning English through Case Law series. In this video we will study Case Law No. 51/2021/L on determining the ownership of the car parking arena in apartment building. Including 5 parts, Part 1, Source of the Case Law, Part 2, Overview of the Case Law, Part 3, Content of the Case, Part 4, Assessment of the Court, Part 5. Rules. This case was approved by the Council of Judges of the Supreme People's Court on November 25, 2021 and announced in Decision Number 594/QDCA dated December 31, 2021 of the Chief Justice of the Supreme People's Court. Judgment Number 82/2020/DSPT dated 06 March 23, 2020 of the Hanoi People's Court on the case of requesting to declare the service contract invalid, requesting recognition of the right to own the basement floor between the plaintiff being S Urban Development and Construction Investment Joint Stock Company and the defendant being the management board of the H Complex building. The person with related interests and obligations includes 03 people. Part 2. Overview of the Case Law. Case Law Content. The car parking area of the apartment building was built according to the standards and was not allocated to the selling price of the apartment in the apartment purchase and sale contract. Legal solutions. In this case, the court must determine that the parking area of the apartment building belongs to the investor's private ownership. Keywords of the case law: apartment, basement for car parking, private ownership of the investor. Part 3. Content of the case. According to the petition and the testimonies during the settlement of the case, the plaintiff and his authorized representative presented S Urban Development and Construction Investment Joint Stock Company, hereinafter referred to as Company S, is licensed by the competent authority to act as the investor of the project of Complex Building H, located at KM 10, Road A, Ward B, District C, Hanoi, which is presently number 131, Street A, Ward B, District C, Hanoi. According to the project's legal documents approved by the competent state agencies. The building consists of 34 floors, excluding technical floors and roof floors, and 02 basements, in which the area for commercial and service offices from floor 1 to floor 8 are directly traded or leased by Company S. The building construction was started from the end of 2008 and finished by the end of. The area of 02 basements and the commercial and service floors of the building is under the exclusive ownership of the company and is included in the list of investment properties for depreciation according to regulations. The cost of building the basement and the commercial service area is calculated separately and not included in the selling price of the apartment building of the building. From November 2008, the company opened apartments for sale, and at the end of 2010 the building was officially put into use. After beginning the operation, Company S hired a professional unit to manage and operate the building, then assigned to the Housing Project Management Board H an affiliated unit of Company S to implement. Since August 2016, the H Housing Project Management Board has changed into D Service Business and Management Single Member Company Limited to meet the requirements of building management and operation in accordance with the provisions of Circular No. Circular 02/2016/TTBXD on promulgating regulations on management and use of apartment buildings. On September 26, 2016, Company S and the owners of the building held the first apartment building meeting to elect the Building Management Board and issued the operating regulations of the Complex Building Management Board H. Accordingly, there are 05 members of the Building Management Board, including 03 representatives for the residential block, 01 representative for the commercial, office and 01 representative for the investor. The management board of the building is organized to operate according to the model of the board of directors of a cooperative. The Building Management Board was recognized by the People's Committee of Ha Dong District according to Decision Number 10974/QD, People's Committee dated November 15, 2016. After the Building Management Board was established, D Service Business and Management Single Member Limited Liability Company continued to be the unit implementing the management and operation of the building. However, on August 24, 2017, The Building Management Board, represented by Mr. Dutai S1, head of the Board of Management, signed a service contract for Apartment Building Operation Management number 01/2017/HDDV with another unit providing management and operation services for the apartment building, being G Joint Stock Company, which does not comply with the provisions of the law. Meaning, the management board of the building has not held a meeting and made a minutes to reach the consensus of at least 75% of the members of the building management board on the proposal to change the operating management unit according to regulations in Article 25 of Circular Number 02/2016/TTBXD. The building management board has not held an apartment building conference to reach the consensus of at least 50% of the building owners' representatives on agreeing to change the transportation management service provider operating apartment buildings as prescribed in Article 14 of Circular No. 02/2016/TTBXD. The content of the Operation Management Service contract signed between Mr. Dutai S1, head of the Building Management Board, and G Joint Stock Company on August 24, 2017, contains a clause that infringes upon the investor's ownership rights. Specifically, the Building Management Board has deliberately decided on the part of the property which is under the sole ownership of Company S without the consent of the company, at point N, Clause 1, Article 3 of the service contract between the Board of Management and Joint Stock Company G. The two parties have agreed on car parking services at 02 basements of the building, which is under the private ownership of Company S. In the apartment sale contract, as well as in all related documents, there is no provision to record or show the content that the basement for parking cars, motorbikes, and the floors from the first to the 8th floor is under the common ownership of the building. However, the management board of the building arbitrarily hired Company G and Company Y to occupy and collect money for illegal parking at 02 basements from September 2017 to present. The building management board sealed the door of the supermarket warehouse on the first floor behind the building, thus hindering the business activities and the escape route of MediaMart Tan Shan Supermarket from October 2017 until now. Company South proposes the court to recognize the parking area as described in the building completion documents of first basement floor with an area of 2,330 square meters, second basement floor with an area of 2,050 square meters is under the sole ownership of the investor. Force the Building Management Board and Joint Stock Company G to return this area to Company S, declare the service contract of Apartment Building Operation Management number 01/2017/HDDV signed on August 24, 2017 between the Building Management Board and G Joint Stock Company and Service Provision Contract No. 02/2019/HDDV/BQTYB signed on February 1, 2019 between the Management Board of the building and the Y Apartment Building Management and Operation Company, Limited invalid. Force the Building Management Board and G Joint Stock Company to restore the original condition of the back door of the first floor of MediaMart Tan Shan Supermarket and compensate for damage caused by illegal infringement, affecting the Company S's business activities. During the settlement of the case and at the first instance court hearing, the plaintiff withdrew the claim for compensation for damage caused by illegal infringement of the parking area in 02 basements, affecting the business activities of the company, reserves the right to sue for this damage in another case. Respondent, the Management Board of H Complex Building, Mr. Dutai S1 presented, the Management Board of the H Complex Building was legally established and recognized according to Decision Number 10974 dated November 15, 2016 of the People's Committee of Ha Dong District. According to this decision, the members of the Board of Directors include Mr. Dutai S1, Mr. Tran Van T, Mr. Nguyen Vu G1, Mr. Trin Shin T1, Mr. Nguyen Khan T2. Around March 2017, Mrs. Bui T.N. replaced Mr. Nguyen Khan T2. On August 27, 2018, Mr. Nguyen Van L. replaced Ms. Bui T.N. Currently, the Board of Directors includes 5 members, Mr. Dutai S1, Mr. Tran Van T, Mr. Nguyen Vu G1, Mr. Trin Shin T1 and Mr. Nguyen Van L. Initially, when the apartment building was just put into operation without a board of management, the management and operation of the building was performed by a professional hired by Company S, but it was not legal. Until November 15, 2016, when the Building Management Board was established. It hired Company G to operate and manage this building. The process of performing the service contract performed by Company G was not in accordance with the contract, so the Board of Management liquidated the contract with Company G on March 23, 2019. Right after that, the Board of Management continued to sign a contract for building operation and management services with Y Apartment Building Management and Operation Company, Ltd. Regarding the plaintiff's request to declare the building operation and management contract invalid, the defendant did not agree because the plaintiff did not have the authority to request this settlement, the reason being that the new building was put into use at the end of 2010. According to the regulations of Circular Number 02 of the Ministry of Construction, after 1 year of use, the investor is responsible for electing the management board of the building. However, beyond the above time limit, the investor did not establish a management board in accordance with the law. The Building Management Board was established after 6 years, specifically on September 26, 2016. On August 24, 2017, the Board of Management signed a service contract with Company G. During the implementation of the contract, Company G fully and strictly complied with the provisions of the law, no violations occurred. On the other hand, up to this point, the Board of Directors has also liquidated the contract with Company G. Moreover, the investor's area no longer exists in this building, so it has no right to request to invalidate the services contract with Company G. Regarding the request to determine the parking area in the basement is of the investor's ownership. Based on the content of the contract, there is no provision that this basement is under the management and use of the investor, so the area of these two basements is a common area. According to the financial statements from 2010 to 2016 of the company, there is no mention of the parking area of the two basements. From 2016 up to now, the company has added this area to the report. It is recommended that the investor present the financial plan approved by the Department of Finance, including the building construction dossier approved by the Construction Department and the State Audited Completion Document and the Finance Department's document. If these three units determine that the investor has invested in building the two basements, according to the 2015 housing law, the parking area of the building is a parking space for residents, so it must be determined that it is of common ownership. Therefore, the parking area in these two basements will not be returned to the investor, but will be calculated into value payable to the investor. Regarding the request to restore the original state of the warehouse door of the first-floor supermarket and request the management board to compensate for damage caused by the act of illegally infringing or illegal use of the company's property, of which the Board of Management is not involved and did not perform these acts, so it shall not be responsible to compensate or restore the status quo. Mr. Trin Shin T1 and Mr. Tran Van T, members of the Board of Management, presented. Mr. T1 and Mr. T have the same opinion as Company South request the court to declare the apartment building operation and management service contract number 01/2017/HDDV signed on August 24, 2017 between the Building Management Board and G Joint Stock Company and Service Supply Contract No. 02/2019/HDDV/BQTYB signed on February 1, 2019 between Y Apartment Building Management and Operation Company Limited and the Building Management Board is invalid. Recognize the parking space at Basement 1 with an area of 2,330 square meters, Basement 2 with an area of 2,050 square meters under the ownership of the investment owner. Force the Management Board of the building and the G Joint Stock Company to return this area to Company S. Force the Building Management Board and G Joint Stock Company to restore the original status of the back door of the first-floor supermarket and compensate for damage caused by illegal trespassing affecting the company's business activities. Persons with related rights and obligations. 1. G Joint Stock Company, hereinafter referred to as Company G, presents. Company G has a business registration in the field of management and operation of apartment buildings. On August 24, 2017, Company G signed a service contract with the Management Board of Complex Building H, represented by Mr. Dutias 1, to provide operation services for the apartment building number 131, A Street, Ward B, District C. According to the agreement in the contract, effective from September 1, 2017 to December 30, 2019. The work under the agreement is to provide security, sanitation, technical and other services. The contract is agreed to take and spend on the pricing principle prescribed by the Management Board. The number of vehicles and M2 of service charges provided by the Management Board. Company G collects money on the basis of the database provided by the management board, and the management board sets the fee rates for all types of services. After signing the contract, Company G has paid all the initial costs such as electricity payment for Hadong Electricity in August, technical equipment for operation, smart parking. Until now the company has not recovered all its investment capital, still supporting about 100 million VND in this building project. On January 15, 2019, the company learned that the board of directors signed a building operation service contract with another company. The board of directors arbitrarily put another company into the building operation. Unilaterally terminated the contract with Company G without any discussion, and so far there has been no document on liquidation. In fact, from January 20, 2019, Company G does not operate this building. Regarding the request of the plaintiff, the company is no longer operating or managing this building, has no relation, so it has no opinion. The problems arose between the Company G and the management B. 2. Y Apartment Building Management and Operation Company Limited, hereinafter referred to as Company Y, presents. Company Y signed an implementing a service supply contract for H Complex Building from March 1, 2019. The company has a contract signed with the board of directors, not with Company D. The company has signed and performed the contract in accordance with the provisions of law. When the company took over the work of building management, it did not have to invest in technical equipment such as card scanning machines. For the request of the plaintiff, Company Y proposes to settle according to provisions of law. 3. M Vietnam Joint Stock Company, hereinafter referred to as Company M, presents. In September 2010, Company M signed a premise lease contract with Company S at Building H, address 131 A Street, Ward B, District C. Initially, the two parties signed a contract to lease the basement and floors from the first to the fifth floor of the building. Until about 2014, Company M only rented the first, second and third floors of the building for business and office use. There was no problem with the implementation of the contract. In 2017, after the Board of Management was established, the Board of Management continuously caused difficulties and caused damage to the business of M Company. Now Company S has initiated lawsuit. Company M agreed with Company S's claims, request the Board of Management to stop hindering business operation of Company M and destroy the back wall behind the first floor. In the first instance civil judgment number 40/2019/DSST dated October 31, 2019 of the People's Court of Hadong District, Hanoi City judged, 1. Partially accept the petition of S Urban Development and Construction Investment Joint Stock Company. Determine and recognize the car parking area at basement 1 of 942.5 square meters and the car parking area at basement 2 of 1,882.5 square meters under the ownership of S Urban Construction and Development Investment Joint Stock Company. Declare the building operation. Management Service Contract No. 01 dated August 24, 2017 between Mr. Du Thai S1 Head of Building Management Board and G Company and Service Supply Contract No February 2019/HDDV/BQTYB dated February 1, 2019 between Y Apartment Building Management and Operation Company Limited and the Board of Management of H Complex Building is invalid. Urban Development and Construction Investment Joint Stock Company has the right to dismantle and restore the original condition of the rear door of the first floor of H Complex Building in accordance with the design documents approved by competent authorities. 2. Terminate the claim of compensation from S Urban Development and Construction Investment Joint Stock Company towards Company G and Mr. Du Thai S1 for damage caused. In addition, the judgment also decided on the court costs, the right to appeal and the obligation to execute the judgment of the involved parties, disagreeing with the decision of the first instance judgment. On December 2, 2019, Mr. Du Thai S1 appealed as the representative of the defendant Management Board of H Complex Building and stated that the court granted the first instance trial was not objective, did not comply with the provisions of the law, quoted laws that were not included in the legal documents promulgated by competent state agencies, seriously infringed upon legitimate rights and interests of building residents. Suggestion: abrogate the entire first instance judgment, determine and recognize the entire area of 2 basements for parking under the common ownership of H Complex Building, clarifying ownership of 03 commercial floors of H Complex Building, including the wall behind the first floor that the investor is leasing to another unit. Request the plaintiff to finalize and hand over maintenance costs, hand over building documents, complete and hand over the fire prevention and fighting system, hand over and tally building equipment, and hand over the common, private areas to the Board of Management representing the residents in accordance with the provisions of the law. At the appellate court hearing, the plaintiff upheld the initial claims and agreed with the first instance judgment. The defendant upheld the appeal request, disagreed with the first instance judgment and proposed to reject the plaintiff's petition. The lawyer defending the legitimate rights and interests of the plaintiff, after presenting his views on protecting the legitimate rights and interests of the plaintiff, proposes the appellate trial panel to reject the defendant's entire appeal request. Uphold the decision of the first instance judgment, accept the plaintiff's petition for legal property rights over the parking area at 2 basement floors and invalidate 2 contracts for management and operation services which have been signed by the Board of Management with G Company and Y Apartment Building Management and Operation Company Limited, at Building 131, A Street, Ward B, District C, Hanoi. The representative of the People's Procuracy of Hanoi City expressed his opinion regarding the procedures. Procedure conducting persons and procedure participants strictly complied with the provisions of the Civil Procedure Code. Regarding the content, after analyzing the content of the case and considering the defendant's appeal, the representative of the Hanoi People's Procuracy stated: basis for determining the ownership of the area in 2 basements of Building 13, Street A, Ward B, District C, Hanoi, at the time of purchasing apartments by the end of 2008 to 2010, there was no regulation on shared and private ownership, so the apartment sale contract with residents did not clearly show the common and private area. Pursuant to official letter number 279/BXD dated October 18, 2017 of the Ministry of Construction Guiding Company S, pursuant to decision number 12 dated April 25, 2008 of the Board of Management of Company S approving the investment project to build the H Complex building, pursuant to official letter number 20005/18/CVAZ dated November 6, 2017 and official letter number 20014/18/CVAZ dated January 18, 2018 of the Auditing and Consulting Company Limited, confirmed revenue and expenses from the business of 2 basements have been accounted and declared for value-added tax, corporate income tax every year. Construction cost of the H Complex building allocated to 2 basements is VND 229,191,000, which is recorded as an increase in the company's fixed assets, not allocated to the cost of apartments. There are enough grounds to determine the parking area at 2 basements 1 and 2 at the H Complex building are under the management of Company S. The representative of the People's Procuracy of Hanoi City expressed his opinion regarding the procedures. Procedure conducting persons and procedure participants strictly complied with the provisions of the Civil Procedure Code. Regarding the content, after analyzing the content of the case and considering the defendant's appeal, the representative of the Hanoi People's Procuracy stated: basis for determining the ownership of the area in 2 basements of Building 13, Street A, Ward B, District C, Hanoi, at the time of purchasing apartments by the end of 2008 to 2010, there was no regulation on shared and private ownership, so the apartment sale contract with residents did not clearly show the common and private area. Pursuant to official letter number 279/BXD dated October 18, 2017 of the Ministry of Construction Guiding Company S, pursuant to decision number 12 dated April 25, 2008 of the Board of Management of Company S approving the investment project to build the H Complex building, pursuant to official letter number 20005/18/CVAZ dated November 6, 2017 and official letter number 20014/18/CVAZ dated January 18, 2018 of the Auditing and Consulting Company Limited, confirmed revenue and expenses from the business of 2 basements have been accounted and declared for value-added tax, corporate income tax every year. Construction cost of the H Complex building allocated to 2 basements is VND 229,191,000, which is recorded as an increase in the company's fixed assets, not allocated to the cost of apartments. There are enough grounds to determine the parking area at 2 basements 1 and 2 at the H Complex building are under the management of Company S. However, according to the provisions of Point C, Clause 2, Clause 3, Article 49 of Decree No. 71/2010/NDCP stipulating the shared ownership of an apartment building, the parking space, bicycles, vehicles for the disabled, two-wheeler, is determined to be of shared ownership of the apartment building. As for the car parking area, because it is not allocated to the selling price of the apartment, so there are grounds to say such areas are of the investor's private ownership. As for Apartment Building Operation and Management Service Contract Number 01/2017/HDDV signed on August 24, 2017 between the Building Management Board and G Joint Stock Company, and Service Provision Contract Number 02/2019/HDDV/BQTYB signed on February. As for the determination of ownership of 3 commercial basements of H Complex Building, including the wall built behind the floor 1. Pursuant to Decision Number 461 dated March 4, 2008 of the People's Committee of Hatay Province on approving the investment project to build H Complex Building, Official Letter Number 6606 dated December 6, 2010 of the People's Committee of Hanoi City on changing the function of the 6th, 7th, and 8th floors from the apartment function to the office function. Official Letter 7494 dated November 5, 2014 of the Hanoi People's Committee on the transfer of the 4th and 5th floors from commercial functions to office functions. Their content shows, H Complex Building Project has 34 ground floors, 02 basements, of which from 1st to 8th floor are service, commercial and office areas. Strictly comply with the law, Company S has sold and leased the areas in the building corresponding proper uses. Therefore, there are grounds to determine that 03 commercial floors of H Complex Building are owned by the investor. The first instance judgment has decided that S Urban Development and Construction Investment Joint Stock Company has the right to dismantle and restore the original rear door of the first floor of H Complex Building in accordance with the design documents approved by competent state agencies is grounded. As for the defendant's request that the plaintiff must settle and hand over the maintenance cost, hand over the building documents, complete and hand over the fire prevention and fighting system, and hand over and tally the equipment of the building, handing over the shared, private areas to the board of directors representing the residents. However, in the process of settling the case at the first instance stage, the defendant did not make such counterclaim, so there was no basis for requesting the appellate trial panel to consider it. From the above analysis, it is found that the appeal of the defendant is ungrounded. However, the first instance judgment did not specify the location of the car parking space and the motorbike parking space, leading to difficulties for judgment enforcement, suggesting the appellate trial panel to be based on Clause 2, Article 308 of the Code of Civil Procedures, amending the first instance judgment, supplementing the determination of the location of parking spaces for cars and motorbikes as a basis for judgment enforcement. Part 4. Assessment of the Court's findings. 1. After studying the documents in the case file, examined at the court session, and based on the results of debate at the court session, the trial panel concluded. 2. Regarding the proceedings, 3. The defendant filed an appeal within the statutory time limit and paid the appellate court fee advance, which should be determined as valid. 4. As for the absence of persons with related interests and obligations without an appeal, despite being duly summoned by the court, they are absent from the trial for no reason. Pursuant to Article 296 of the Civil Procedure Code, the court shall conduct the trial according to the provisions of law. 5. Regarding the content, considering the defendant's appeal request. 6. Basis for determining the ownership of the parking area in the 2 basements. 7. S Urban Development and Construction Investment Joint Stock Company licensed by competent state agencies is the investor of H Complex Building Project, address at 131 A Street, Ward B, District C, Hanoi. This project has 34 floors, not including technical floors and roofs, and 2 basements, of which from 1st to 8th floors are service, commercial and office areas. The company has sold and leased the area in the building according to the proper use. On September 26, 2016, at the First Apartment Building Conference, the regulation was issued and the management board of H Complex Building was established, consisting of 03 representatives for the residents, 01 representative for the investor and 01 representative for the commercial and office sector. The management board of the building was organized to operate according to the model of the board of directors of the cooperative and was recognized by the People's Committee of District D according to Decision Number 10974/QDUB&D dated November 15, 2016, revised twice after that. According to the operating regulations of the Board of Management, there must be a building operation management company. D Management and Service Single Member LLC is working as an operation manager and continues to be the unit implementing the management and operation of the building. On August 24, 2017, the management board of the building signed a service contract for Apartment Building Operation Management number 01/2017/HDDV with a new Apartment Building Operation Management Service provider, which is G Joint Stock Company. In February 2019, the Board of Management again signed an Apartment Building Operation Management Service contract with Company Y. 8. Plaintiff, Company S stated that the Board of Management had infringed on the company's ownership rights by appropriating the parking space in two basements, built and sealed the warehouse door behind the supermarket on the first floor. The signing of an apartment building management contract by the Board of Management does not comply with the provisions of Articles 14 and 25 of Circular No. 02/2016/TTBXD, without the consent of at least 75%, 4/5, member of the Building Management Board on the proposal to change the operating management unit. Failed to reach the consensus of at least more than 50% of building owner representatives. The content of the operation management service contract infringed on the investor's ownership rights, arbitrarily decided on the parking space at 02 basement floors. 9. Considering that the time when the company was approved for the construction investment of H complex building project as well as the time when the company implements the project and signs the apartment sale contracts with the residents was done from the end of 2008 to 2010. Pursuant to the 2005 Law on Housing and Decree 71/2010/NDCP dated June 23, 2010 detailing and guiding the implementation of the Law on Housing, at Point B, Clause 1, Article 49 of the Law on Housing defined the area under private ownership of the investor keeps, does not sell and does not allocate the value of this privately owned area to the selling price of the apartment for the owners of the apartment. 10. C. Clause 2, Clause 3, Article 49 of Decree No. 71/2010/NDCP stipulates the share ownership in the apartment building as follows. 11. Parking spaces, bicycles, vehicles for the disabled, two-wheeled motor vehicles, are built according to construction standards and can be arranged in the basement or on the first floor or in another area inside or outside the apartment building. 12. As for the car parking area, it must be built according to the construction regulations but can be decided by the investor to be under shared ownership of the apartment owner or under the private ownership of the apartment owner. 13. Private-owned and shared-owned parts of the apartment building specified in this article must be clearly stated in the apartment purchase and sale contract. C. Clause 8, Article 4 of Decision No. 01/2013/QDUBND dated January 4, 2013 promulgating regulations on management and use of apartment buildings in Hanoi City. In the definition of terms, implementation of Article 70 of the Housing Law, Article 49 of Decree No. 71/2010/NDCP, Article 4 of Decision No. 08/2008/QDBXD, pursuant to Decision No. 01 of Hanoi City People's Committee explains the words of this decree. For the car parking area in the basement, which is decided by the investor whether falling under the shared ownership of the apartment building or private ownership by the investor. If the parking lot in the basement is allocated to the price of the apartment for the owners of the apartment building, it is part of the shared ownership. If not allocated to the price of the apartment, it is privately owned by the investor. But 15. In Official Letter No. 279 dated October 18, 2017 of the Ministry of Construction sent to U.S. Urban Development and Construction Investment Joint Stock Company, BL 370, quoted, according to the attached documents, the apartment purchase and sale contract signed between the company and the customer does not have an agreement on shared and private ownership. Therefore, the investor needs to have documents to prove that the construction investment cost has not been allocated with the area of the basement and the commercial service area into the selling price of the apartment. In case the papers and documents proving that the investor has not included the construction investment expenses of the above-mentioned area in the selling price for the buyer, this area shall be owned exclusively by the investor, and the investor must ensure that these areas are properly used for the right purposes and functions according to the project documents approved by the competent authority as well as the relevant provisions in the purchase contract with the customer. 16. The determination of whether the investor has allocated or not allocated construction investment costs for the area of the basement and the commercial service area to the selling price of the apartment is based on the contents of the project approved by competent authority and audited financial statements. 17. In official letter number 2.0018/19/CV/KTTV dated October 23, 2019 of Hanoi Branch of E Auditing and Consulting Company, Limited, sent to the People's Court of Ha Dong District showed. 18. In official letter number 2.0018/19/CV/KTTV dated October 23, 2019 of Hanoi Branch of E Auditing and Consulting Company, Limited, sent to the People's Court of Ha Dong District showed. 19. The company's annual audited financial statements show the taxes the company must pay to the state, including VAT, corporate income tax, personal income tax, and business license tax, land using tax, in which 20. VAT and corporate income tax related to the business of car parking services in 2 basements are declared and paid by S Urban Construction and Development Investment Joint Stock Company showed on the annual financial statements from 2017 and earlier. The company's financial statements for 2018 and 6 months of 2019 no longer reflect this business activity. 21. The land tax over the construction area of H Complex Building, the Urban Development and Construction Investment Joint Stock Company paid according to the notice of the Tax Department of Ha Dong District was VND 23. 850000/year, 22. Based on the regulations as well as the responses of the Ministry of Construction and the Branch of E Auditing Company as above mentioned, the area under shared ownership of building apartment residents is the place parking, bicycles, vehicles for the disabled, 2-wheeled motor vehicles. Particularly for the car parking area in the basement, the investor decides whether the area is of shared ownership or private ownership of the investor. According to the apartment purchase and sale contract, the parking space for cars in the basement is not allocated to the price of the apartment, so it is determined to be of private ownership of the investor. Therefore, the Court of First Instance partially accepted the petition of Company S on the ownership recognition of the investor toward the car parking area in the Basement 1 and Basement 2 of H Complex Building located at 131 A Street, Ward B, District C, Hanoi is grounded. 24. The second basement parking area is 2,050 square meters, in which located 68 parking spaces for cars and 67 parking spaces for motorbikes. 25. In order to determine the positions of car, motorbikes parking slots, after the argument session of the appellate trial on June 3, 2020, Hanoi People's Court suspended the case to conduct on-site appraisal, determining the locations to serve as a basis for solving the case. However, on March 19, 2020, when Hanoi People's Court arrived at the basement of the building according to the trial suspend decision on March 6, 2020, there were many people who were not participants of the case participated in the on-site appraisal. These people obstructed and did not allow the appraisal of the court, so the appraisal could not be conducted. The fault belonged to the defendant. 26. Therefore, in order to have ground for determining the locations of the car, motorbike parking slots, after listening to the presentation of the participants, considering the written explanation of the plaintiff and the detailed drawings, the trial panel found it consistent with the construction design drawings and the building completed drawings provided by the plaintiff at the first instance stage, on that basis to determine the location and area of the cars, motorbikes parking slots at the 2 basements of the building as a basis to solve the case. 27. Pursuant to Decision Number 26/2004 dated November 2, 2004 of the Minister of Ministry of Construction on promulgating TCXDV and 323, 2004 High-Rise Buildings Standard Design, 28. Standard car parking slot is 25 square meters per car. 29. Standard motorbikes, 2 motorbikes/household with the standard from 2.5 square meters per vehicle to 30 m2/vehicle and 1 bicycle/household with the standard of 0.9 square meters per vehicle. 30. H Complex building has 228 apartments x 2 motorbikes / 1 household equals 456 motorbikes x 2.5 square meters / 1 household equals 140 square meters and 01 bicycle / 01 household equals 228 vehicles x 0.9 square meters equals 205 2m2. The total area of parking space for motorbikes and bicycles is 1,345.2 square meters. According to the design drawings and completed documents, the parking space in basement 1 is for 555 motorbikes, basement 2 is for 67 motorbikes, totaling 622 vehicles x 2.5 square meters / vehicle equals 1,555 square meters, exceed the parking area of 228 apartments. 31. However, the first instance court only took the total parking area of the two basements minus the parking area for motorbike. The remaining area, considered to be the car park of the investor, was not accurate, inconsistent with design drawings and completed records, caused difficulty for judgment enforcement. Therefore, the appellate court amended this section, inconsistent with the area and location of the actual car, motorbike parking space, 32, for the request to declare two apartment house operator service contracts no. January 2017/HDDV signed on August 24, 2017 between the Building Management Board and G Joint Stock Company, and the supply contract February 2019/HDDV/BQTYB signed on January 2, 2019 between Y Apartment Management Company Limited and the Building Management Board, found that 32. The Management Board of H Complex Building was elected by the Apartment Building Conference and recognized by the People's Committee of Ha Dong District under Decision No. 10974 dated November 15, 2016, first change on April 3, 2018 and second change on August 27, 2018. According to the law, the Board of Management is allowed to sign contracts with apartment management service operators that has the function of managing the apartment but must comply with the provisions of the law. However, when signing the two above-mentioned service contracts, the Management Board did not comply to the procedure prescribed in Circular 02/2016/TTBXD dated February 15, 2016 of the Ministry of Construction, and the operation regulations of the Management Board, arbitrarily changed the Management and Operation Company, did not hold the Apartment Building Conference, did not reach the approval of at least 50% of the representatives of the apartment owners who received apartment handover, attended the conference, did not hold a meeting of the Management Board, not reaching approval of at least 75% of the members of the Management Board. The defendant stated that they liquidated the service contract with Company G, but Company G presented that they actually stopped the operation management of the building from February 2019 to present, but no written contract liquidation made. The Board of Management signed a service provision contract with Y Apartment Management Company Limited without liquidating the contract with G Joint Stock Company is not inconsistent with the law. The above two operational management service contracts still currently exist in practice. The content violated to the investor's interests, managing both basements. Therefore, the first instance court accepted the plaintiff's request to declare that the two above-mentioned operation management service contracts were invalid was grounded. 34. However, the two participants did not require settlement of the consequences of the invalid contracts in the case, so the first instance court did not consider it was in consistence with the law. In the event of dissatisfaction, the participants might initiate such request in another case. 35. For the determination of ownership of 3 commercial floors of H Complex building with the wall built behind the first floor. Pursuant to Decision No. 461/QDUB&D dated March 4, 2008 of the People's Committee People of Province T on approval of construction investment project of H Complex building. Official Letter 9906/People's Committee XD dated December 6, 2010 of the Hanoi People's Committee on the conversion of the functions of the 6th, 7th, and 8th floors from commercial function to office function. Official Letter No. 7495/VPQHKD dated November 5, 2014 of the Hanoi People's Committee on the conversion of the 4th and 5th floors from commercial to office functions. These are the bases for defining 03 commercial floors of H Complex building belong to the investor. The investor has sold and leased such floors in consistence with their proper function. On that basis, in addition to determining the ownership rights, the first instance court decided that Urban Construction and Development Joint Stock Company has the right to dismantle and restore the original state of the door behind the first floor of the building of H Complex building in accordance with the design documents approved by competent state agencies was grounded. 36. As for the defendant's request that the investor must finalize and hand over maintenance costs, hand over building documents, complete and hand over the fire prevention and fighting system, hand over and tally the building equipment, hand over the shared and private areas to the Board of Management representing the residents. Finding that, in the process of settlement at the first instance court, the defendant did not request for such counterclaim, persons with related interests and obligations had no independent claim. The first instance court did not consider and settle it was lawful, the appellate court has no basis to accept such appeal of the defendant. 37. Regarding that the plaintiff partially withdrew the initial claim, required Mr. Dutias 1 and Company G to pay compensation for damage caused by illegal acts affecting the business activities of Company S. The claim withdrawal was completely voluntary, the first instance court terminated such claim was lawful. 38. However, in the citation of the provisions of the law, there were some missing or not correct contents. The defendant appealed this content was grounded, the appellate court must revise the judgment to conform with the provisions of the law. Other appellate content of the appeal was groundless, so the appellate trial panel has no basis for acceptance. 39. The statement of the lawyer defending the legitimate rights and interests of the plaintiff and the proposal view of the representative of the Hanoi People's Procuracy are grounded and should be accepted. 40. Regarding the court fee, the Management Board of H Complex Building must bear the legal fees in accordance with the law. Urban Construction and Development Investment Company's claim is partially accepted, so it shall bear the court fee of the part of claim which was not accepted. Part 5 Rules. Pursuant to Clause 2, Article 308 of the Civil Procedure Code, pursuant to Article 163, Article 164, Article 169 of the 2015 Civil Code, pursuant to the 2005 Law on Housing, pursuant to Decree 71/2010/NDCP dated June 23, 2010 of the Government, pursuant to Resolution Number 326/2016/UBTVQH14 dated December 30, 2016 of the National Assembly Standing Committee stipulating the rates of collection, exemption, reduction, payment, management and use of court fees and charges, adjust the first Instance Civil Judgment Number 40/2019/DSST dated October 31, 2019 of the People's Court of Ha Dong District, Hanoi City. Verdict: partially accept the petition of Urban Development and Construction Investment Joint Stock Company against the Management Board of H Complex Building on recognizing the parking area for cars at the Basement 1 and Basement 2 of H Complex Building located at 131 A Street, Ward B, District C, Hanoi City, owned by Urban Development and Construction Investment Joint Stock Company. Determination and recognition of car parking area at Basement 1 being 600 square meters, the car parking area at Basement 2 being 1,700 square meters, owned by Urban Development and Construction Investment Joint Stock Company. Based on the detailed drawing attached to the judgment, determine the specific location of the parking space for cars and motorbikes as follows. Parking area in Basement 1 is 2.330 square meters, of which 600 square meters, including Circulation Road, is divided into 24 car parking spaces. The location of the car parking is determined from the length of the E-axis to the F-axis, from the E-axis to the C-axis, from axis 1 to the extended axis 6, number from 1 to 11 and from 14 to 26 in detailed drawings, except for the core area of the elevator. The motorbike parking area is 1,387.5 square meters, including circulation roads, divided into 555 motorbikes parking slot. The location for the motorbike parking space is determined from half the length of F-axis to E-axis, from F-axis to extended G-axis, from D-axis to extended A-axis, and from axis 1 to extended axis 6, minus the area of functional areas. The location for the generator is 42 square meters, from A-axis to B-axis, the outermost from extended axis 1. The remaining area of Basement 1 is determined as 2,330 square meters to 600 square meters, 1,387.5 square meters to 42 square meters equals 300.5 square meters. This is the air circulation space of the investor to create ventilation in Basement 1. parking area in basement 2 is 2,050 square meters, of which 1,700 square meters is the area for car parking, including Circulation Road, divided into 68 car parking slots. The location of the car parking is determined from 3/4 the length of the F-axis to the G-axis, from the F-axis to the extended A-axis, and within the area from axis 1 to the extended axis 6, except for the elevator core area and other functional areas. The motorbike parking area is 167.5 square meters, including the Circulation Road, divided into 67 parking spaces for motorbikes. The motorcycle parking position is determined from 1/4 the length of the G-axis extending to the F-axis plus the extended G-axis, in the area from axis 2 to axis 5 and in the area from 1/2 the length of axis 1 to axis 2 and the G-axis to D-axis, minus the functional areas. The remaining area of basement 2 is determined 2,050 square meters, 1,700 square meters to 167.5 square meters equals 182.5 square meters. This is the air circulation space of the investor to create ventilation in basement 2. 2. Declare the Building Operation Management Service Contract number 01/2017/HDDV signed on August 24, 2017 between Mr. Dutias 1, Head of Building Management Board and G Company and Service Supply Contract Case number 02/2019/HDDV/BQTYB dated February 1, 2019. Between Y Apartment Building Management and Operation Company, Ltd. and the Management Board of H Complex Building invalid. In cases where the involved parties cannot reach agreement among themselves on the settlement of consequences of the invalid contract, they have the right to initiate a lawsuit in another civil case according to the provisions of Law. 3. Urban Development and Construction Investment Joint Stock Company has the right to dismantle and restore the original state of the rear door of the first floor of H Complex Building as it was in accordance with the design documents approved by the state agency. 4. Partially terminate the request of the Urban Development and Construction Investment Joint Stock Company on forcing Company G and Mr. Dutias 1 to compensate for damage. Regarding court fees, the Management Board of the H Complex Building must bear 300,000 VND in first instance civil court costs and no appellate court costs. The amount of 300,000 VND installed as an advanced appellate civil court fee as in receipt number 00084776 dated December 5, 2019 at the Civil Judgment Execution Subdepartment of Hadong District, Hanoi City, shall be deducted from the amount of first instance civil court fee payable. Confirm that the defendant has fulfilled the court fee. Urban Construction and Development Joint Stock Company must pay 300,000 VND for first instance civil court fee regarding the unaccepted claim. The amount of 300,000 VND paid as an advance for the appellate civil court according to the receipt number 00016881 dated July 30, 2018 at the Civil Judgment Execution Subdepartment of Hadong District, Hanoi City, shall be deducted from the amount of the first instance civil court fee payable. Confirm that the plaintiff has fulfilled the court fee. In case the judgment be enforced in accordance with the provisions of Article 2 of the Law on Civil Judgment Enforcement, the judgment creditor and the judgment debtor has the right to agree on the judgment enforcement, the right to request the judgment enforcement, to voluntarily execute the judgment as prescribed in Articles 6, 7, 7a and 9 of the Law on Civil Judgment Enforcement. The Judgment Enforcement Statute of Limitations conform with the provisions of Article 30 Law on Civil Judgment Enforcement. The appellate court is judged in public, takes effect from the date of pronounce / Content of the case law. 22. Based on the regulations as well as the responses of the Ministry of Construction and the branch of the auditing company as above mentioned, the area under shared ownership of building apartment residence is the place parking, bicycles, vehicles for the disabled, two-wheeled motor vehicles. Particularly for the car parking area in the basement, the investor decides whether the area is of shared ownership or private ownership of the investor. According to the apartment purchase and sale contract, the parking space for cars in the basement is not allocated to the price of the apartment, so it is determined to be of private ownership of the investor. Therefore, the Court of First Instance partially accepted the petition of Company S on the ownership recognition of the investor toward the car parking area in the Basement 1 and Basement 2 of H Complex Building located at 131 A Street, Ward B, District C, Hanoi is grounded.